Very much, Justice Michael. Thank you all again for attending today, and what we'd like to do now is draw proceedings to a close, and in that regard I'm going to invite Bill Holohan, who is the coordinator of our 3 mediation committees, to speak to you concerning the wrap-up of the process and the day itself. So thank you very, very much. Thank you all to our guests who have taken time out to be with us. It's deeply appreciated. Thank you, Bill.
I had a PowerPoint presentation prepared, but I'm not going to present it for a couple of very simple reasons. As a Limerick-born, now largely Dublin-based Corkman and friends in the north, I'm conscious that there are certain other commitments that people have this evening. David lives in the undulating hills of County Down. I live on the undulating hills of Cork City, and both of us are returning home tonight. But more importantly, the judge has a pressing appointment in Kings at 6. So we have to allow for the travel time, which means we've got about 3 minutes. 6:30. Oh, I can take 6 minutes, that's right. 30 years ago, I qualified as a solicitor, and as with any junior solicitor, I started off with kind of a district court portfolio of work, where I was sent out for those more important than I in the practice would remain back at base. Also, I was in the circuit court, and the circuit judge of the day was Sean Fawcett. And if he didn't like a case, you could tell very rapidly, because the bands would begin to flutter. And the more they fluttered, the more the degree of agitation. And eventually there'd be a the throat would be cleared. And he'd look down over his glasses, and with all the authority he could muster, staring over those glasses, he'd say, "Well, the party's not like to go outside for a while." Which was a judicial encouragement to mediate in a somewhat crude form. And the difference, of course, is that there was nobody mediating. It was a case of negotiation. And everybody was playing with their cards close to their chest. The beauty of mediation being that somebody in the middle gets to see all the cards, and someone will realise whether or not there is a potential ground for settlement. But picking up just the themes that have been spoken about, David said, that lawyers should be advisors, not representatives in mediation. And I have a couple of tricks. Perhaps a CPD seminar at another time we can go into on how to do that thing. But I was worshipping at the satanic altar of litigation, as I described it, for about 25 years before I had this road to Damascus conversion to the Church of Mediation about 7 years ago. And I had become a bit of an evangelist, not quite a Jehovah's Witness version now, but a bit of an evangelist for mediation. So hence, for example, Jim asked me would I take on the job of trying to coordinate the mediation work within the Chartered Institute. One of the presentations that Richard and I presented recently to the Law Society Diploma was in relation to the whole question of courts mediation and the courts rules. And one of the common themes, there was a repeat slide that I had going through. Now, Richard has always commented upon the use of cartoons, but there was one thing that I kept coming up with: the shortcomings. And one of the shortcomings is the stick. We have various kind of carrots to encourage people to go to mediation, but we don't really have sticks. And in dinner conversations, again, which came at a price for the judges involved, with some other judges other than Michael, the issue was we don't really have the power to force people. We can encourage, we can suggest, we can hint, we can facilitate, but we don't actually have the power to say, get thee hence into the dark of the night and settle this. And that's really the problem. Also, there's a well-settled body of law in the UK that I'm not going to bore you with now in relation to implications for costs. And even last week, or 2 weeks ago, 23rd of October, there was a decision in the UK where basically a Marcel Marceau approach to litigation, i.e. a my Marxist version where nothing is said in response to an invitation to mediation, led to an order for costs against a party on the basis that silence equals no. And if you remember Mel Brooks' silent movie, Marcel Marceau, a mime artist, spoke, and the only word he uttered was no. And as far as the courts in England are concerned, silence in response to a request to mediate can now be a no, and that can be at your peril. And we need that kind of reform here as well, in terms of providing an impetus to people to actually mediate. Richard's concept, which he set out very clearly here approximately a year ago, was that there would be a group who would be specially trained, the same as the Dermot's group on planning are being specially trained, and there's another group on workplace who are being specially trained, who will have an insight into and a particular expertise for dealing with this type of mediation. And the hope is that Michael will be able to take the word back to his brethren and sistren judges and say to them, look, You need to get a pair of glasses that you can look over and harumph and develop a cough and get on to know Rubottom in the courts rules committee and get the rules changed so that there is a bite. Equally, the minister needs to do something in terms of the bill and to provide a bite that if people do not mediate, then there are cost implications. Now that's the stick. The carrot is that people need to be educated, back to education, about the fact that there is a benefit to it. And I give the example of Michael O'Brien, a partner in Barry C. Galvin's in Cork. Now you know Cork lawyers have a particular reputation for being antagonistic. But Michael was brought along as a very seasoned practitioner to talk about his experiences very late in life of mediation. And he gave a very short but very sweet speech, which actually said more to the practitioners than a lot of more eloquent and more lengthy contributions. And he said, you know, I was very suspicious about this mediation lark. You know, I hadn't done it, and you know what? It wasn't bad. And we got a result, and we settled, and more importantly, I got a good fee. And what people need to understand is, as lawyers, that it's not a question of the clock. It's not a question of, you know, as Michael says, availing of the great tricks and traps that are there in litigation. And only yesterday, I'm involved in a case, and that was the whole subject of discussion. What tips and traps could be used to slow down the opposition in their headlong rush to try and get a judgment on something? But if you become known as a lawyer who within 6 weeks, rather than 6 years, can produce an outcome for a client at little or no expense, apart from the gratitude curve heightened fee that you're going to charge them for producing it in record time, then you will get repeat business. You will become identified as a solutions provider. And that is a lesson that the colleagues need to learn. And if they do learn that, I think that mediation will come. And I will be on the mount singing hallelujah, 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 my day has come. And in the words of the great Negro spiritual, I'd say, Lord, our time has come. And I'm delighted that Judge Michael Peart has honoured us here this evening with his presence. Brendan, as the head of the court service, I'm sure with all the empty courtrooms that are around, will provide the courtroom facilities if necessary for mediation. And everybody will buy into it. So I think that it is the way of the future. And I'm quite happy to say that I am ready to close my contribution as a repentant lawyer. I'll hand back to John.
Thank you, Bill. Ladies and gentlemen, just before we close, I'd like to also extend our gratitude to Anne-Marie Blaney, who is the head of our Communications and PR Special Interest Group. And that particular group and Anne-Marie have assisted tremendously in spreading the word with respect to this event and indeed many others. So thank you, Anne-Marie. I also would like to both welcome and thank Katrina Stewart, who is the person looking after the development of our new faculty, and an important aspect of our work, in that what she's working hard to do is to identify the talent and expertise that exists within the organisation so that we can share it in a collective way and assist the development of our organisation as we go forward. So thank you for coming along today. Thank many of you also for the journeys you've travelled. I appreciate that you've left your day's work to come along, and most of you are travelling back distances and have travelled some distances. So I want to thank you for that. I'd like to thank our guests once again for their contribution and effort, and finally end by wishing you well, and thank you very, very much indeed. Thank you.